Hi guys, welcome to Closer to Closure Summit. I really appreciate you being here today. I'm Dr. Judy Butler. I am the creator of the Guardian's Gift. I am a pastoral psychotherapist. I live in Mebane, North Carolina. I am a private practice, and I consult with and I counsel adult children of aging parents and senior adults. I am here because I have experienced a lot of frustration, a lot of turmoil, a lot of anxiety. Back in 2005, 2006, my father was diagnosed with dementia. And through that journey, I figured out that people don't prepare ahead of time. They're not really ready for what's coming. My parents had a will. Surprisingly, I got hit with a lot of things that I didn't see coming and cost me a lot of money. And I learned the hard way. Some of the things that probably could have been in place weren't, but I experience this every day, all the time with people. I'd like for us to think about the things that we can control, the things that are important in life that sometimes we overlook, that we think we don't have control when everything seems to be spinning out of control. My mission in life is I don't want anybody to have to go through what I went through. And my goal is to reach and help as many people as I can before I leave this earth. I would really hope that I could at least reach 1 million people, 1 million families. And all of you listening today, you can help make that happen. People tell me, oh, I have a will. Well, there's a lot more to this than just a will. And today, we're going to have a wonderful experience of talking with Justin Ervin. He is an attorney in Greensboro. He works with Johnson, Pedrick, and McDonald. They're at 440 West Market Street in Greensboro, as I said. And if you need to contact him later, his number is 336-574-9720. He focuses his practice on estate planning, estate administration, and adult guardianships. Justin enjoys working with all sorts of clients and has a particular affinity for serving the LGBTQIA individuals and non-traditional families. Some people in our Facebook group, this is streaming to Facebook as well. Maybe some of the Hispanic community will see this and know that Justin is available to help them. He actually speaks Spanish. So that's kind of a neat thing when you have attorneys who can actually be fluent and converse with our Hispanic community. Justin is open and active in the local LGBTQIA community, having served on the board of directors of Guilford Green Foundation and the Greensboro LGBTQIA Center, Benevolence Farm, the Greensboro Estate Planning Council, and the Greensboro chapter of the Society of Financial Service Professionals. Justin continues to be involved with his legal alma mater, Elon Law, as an adjunct faculty member and student mentor. Justin completed a double major in business and in French at UNC Greensboro, and then he went on to graduate cum laude from Elon University School of Law and earned an LLM in tax law from the University of Florida. He's licensed to practice in North Carolina and Florida. Justin, would you please, in your professional experience, emphasize why it is so important to have early planning in place?
Well, if you have not put a plan in place, then the state of North Carolina has put one in place for you. Our General Assembly, like the state legislatures of many states, has enacted certain laws that determine who will step into your shoes to wrap up your business affairs after your death, serve as your executor, who will inherit your belongings, your assets, and things like that, and even who will make medical decisions for you if you have not chosen someone to do that. And so putting a plan in place is really making sure that the people that you want in place to make those decisions on your behalf, and the people that you want to benefit from what you've worked so hard your entire life to build up, will actually benefit from those things. So you get to choose who's going to do that. And if you don't make a plan, then like I said, it's our General Assembly that will have made those decisions for you. And part of planning too is trying to anticipate how things could go wrong and putting in contingencies for those sorts of things as well.
What kinds of things do you see that typically on the back end happen that people have to deal with because they haven't planned?
A big thing that I see is minors inheriting. Parents who have small children will often name the children as usually a contingent beneficiary, for example, on a retirement account or on a life insurance policy. And it makes sense that you would want your children to benefit from those things, but when those children are still minors, that can be problematic. It's actually going to push them into a guardianship situation with the court, where someone is going to have to go to court and be appointed as guardian for the child to manage those assets on their behalf and do that under the court's supervision. And that can be involved and expensive. One of the things that you do when you make a plan is figure out, how do I want these things handed over to my children, and build a structure so that your children, instead of inheriting those things directly, can inherit them within a structure. Someone can be in place to handle those assets and give the child guidance. And even if children aren't minors, when I was 22, was I making the best decisions possible? Probably not. So you can met that out over a period of years as well. That's just one sort of thing. Another thing that people like to plan for is what happens when they themselves are no longer able to make the best decisions. As we get older, we all experience different degrees of cognitive loss, and sometimes that's quite tragic, and sometimes it's less so. But putting a plan in place can help people to deal with that.
It's interesting that you talk about different levels of that. I guess the question I really want to know is the difference between a trust or the types of trust. I know there's all different types of trust, but talk about what that means for like minor children or even children, adult children that maybe have drug addiction or alcoholism or some other problems, and why a trust is important and how that works.
That's good that you mentioned substance abuse. And I would include in there other types of compulsive behaviors. Even if you're not using a substance, maybe you're doing other things like compulsive shopping or hoarding or all those sorts of things. And a trust, like I said, is a way that you can put a structure around your assets that you are going to use for your own benefit during your lifetime, and then for someone else's benefit after you're gone. My tax friends would hate this comparison, but I find that it's useful. You can think of a trust like a corporation. They're both entities unto themselves. They have their own legal existence. And a corporation can own factories and employ people and can own fleets of vehicles and own office buildings. And a trust can own assets as well. A trust can own a house and real property, and it can own investments in bank accounts as well. So they can both own assets. Whereas a CEO runs the corporation, a trustee is going to manage the assets inside of the trust. The CEO manages the corporation for the benefit of the shareholders. The trustee manages the assets inside the trust for the benefit of the beneficiaries. If you put together a trust, you can transfer assets in there during your lifetime, or you can set up a will. It's often called a pour-over will that will move assets into the trust after your death. If you put assets in there during your lifetime, then those assets could avoid court-supervised administration, what some people still call probate. And the trustee is going to be there to handle those assets for your benefit if you lose your own capacity to do so during your lifetime, as well as for your beneficiaries after your death. And that could be looking over a beneficiary's shoulder to make sure that they only get as much as they need to live on according to your instructions, if there's a concern that they're going to use that money to buy drugs or to buy other inappropriate things and fill their houses with boxes from QVC, for example. But then also to put a structure around that, to dole it out gradually to children, give them a little bit when they maybe reach age 21, a little bit more when they reach age 30, and maybe wait until they reach age 40 to receive all of it. And you can structure it in other ways as well. If there's a disabled beneficiary who is receiving some sort of public benefits, maybe you want to protect those public benefits and not fill their pockets with money that would disqualify them from receiving those benefits. All good examples of ways to use a trust. A trust can be helpful.
This is very interesting because part of my story is that my mother and I had to figure out how to pay for my dad to be in a nursing home, and my parents didn't have the funds. So we ended up having to put her house in a trust because she was so adamant that she did not want to lose the house. That was all she had, and she felt like the government was going to take her house. And so thanks to an attorney, we were able to save the house, and she's still living, thank goodness. You mentioned probate. Can you say a little more about probate, what that is and how that works?
What most people call probate is actually better described as court-supervised administration. And it's just a process after someone dies that you go to court, you take the will, and you have the court recognize the validity of the will. That's the piece that's actually probate, proving the authenticity of the will, but then also recognize the executor's authority to step into the decedent's shoes and wrap up their affairs, pay their bills that they leave behind, and then distribute whatever might be left over. You have to prepare certain documents and file them with the court to get that process started. Then you also have to report to the court regularly until the estate is wrapped up, until everything is finished. And then the court is going to review all of that and approve it, or might ask you to redo some of it. There are filing fees, court fees that are associated with that. The court does charge fees that are based on the value of the assets that pass through court-supervised administration. And that's one of the reasons that I mentioned that you might, if a trust is appropriate for you and you create a trust, you might want to transfer some of your more valuable assets into the trust during your lifetime so that they'll escape that process of court-supervised administration. Just because you have to go to court after someone dies to administer their estate, that doesn't mean that you have to do a full-blown administration every time. We do have other types of abbreviated administration. For example, if a spouse is surviving, then there are certain things that we can do to get assets over to the spouse. If it's not a spouse, maybe we just have a car. Maybe the decedent owned a car jointly with one of the children, but there wasn't a right of survivorship, so we just have to deal with half of a car. There's an abbreviated form of administration that we can use to deal with that particular piece. But you need to consult with an attorney and figure out which of those processes is right for you, and how can you plan to avoid those or to at least minimize the effect of those processes on your estate.
One of the things that I learned when my dad died in 2018, I learned about a letter of testamentary. Did I say that correctly?
Close.
And what that is and what that means or what that's important for. And also, even if you have a will, there are fees associated with opening and closing an estate. Can you talk a little about those two things?
Sure thing. Letters testamentary is,
There you go.
I think of that as your golden ticket. If you've ever seen Willy Wonka, that's your golden ticket to step into the decedent's shoes, to marshal their assets, to find out information about their assets, information about their debts, pay their debts in the order that the law requires, and then distribute anything that's left over to their beneficiaries. You might also hear of letters of administration or letters of administration CTA, and those are pretty much different varieties of the same thing, just depending on, is there a will, or are we doing this under intestacy, or is there a will but the person acting wasn't named in the will. So whether you hear letters testamentary, letters of administration, or letters of administration CTA, those are basically just different names for the same thing. It's the document that the court gives you so that you can show banks and brokerages and DMV that you have power to act on behalf of the decedent to wrap up their affairs. As far as the costs that are concerned, it does cost money to go and file these pleadings with the court. The court charges fees. It's usually $120 to open an estate that you pay to the court. If you're doing a full administration, then you'll also need to publish a notice to creditors in a newspaper. And the fee for that averages about $100. I've seen it be as inexpensive as $35 and as expensive as close to $500. And that's a fee that you pay to the newspaper. It depends on the county in which the decedent lived. You'll need to file an inventory to the court if you're doing a full administration, and the court is going to charge a fee for that. The minimum fee is only $15, but the actual fee is based on the value of the assets that are shown on that inventory. And it could be as high as $6,000, just depending on the value of the assets. It's 4 per mil. And so you hit that maximum of 6,000 when you file $1.5 million, if you've got $1.5 million of assets on the inventory. And then, like I said, you've got to report to the court. You've got to show the court what you do with these assets, the bills that you've paid, the beneficiaries to whom you've made distributions, and that's on an accounting. And you have to file an accounting every year in North Carolina. And again, it's a $15 minimum fee, but the actual fee is based on the value of the receipts shown on the accounting. It shouldn't be surprising that these filings can be complex. And so you might want to hire an attorney to help you with them, and that's an additional cost. A lot of attorneys do this type of work at an hourly rate, and that can easily get into the thousands of dollars. And I don't want to give anyone the illusion that you can avoid all of these fees by putting together a plan, but you can certainly avoid some even more expensive pitfalls and maybe minimize some of these fees. One of the examples that I gave you was if a minor inherits property, then that's going to throw you into guardianship situation, and you're going to have to administer this minor's estate, much like I just described managing a decedent's estate. You're going to have to qualify as a guardian. You're going to have to file an inventory. You don't do a notice in the newspaper, but then you have to file accountings and you have to be bonded. You have to buy a special type of insurance. The pleadings are very similar for a minor's estate to a decedent's estate. A lot of the fees are similar as well. It can get very complex and very expensive.
You've said the term guardianship a couple of times.
Yeah.
So I know there would be guardianship when we speak about minors, but there's also guardianship for adults with dementia or some sort of Alzheimer's. What kinds of things are involved with that?
So where you have a minor, they can't own and control their own assets. So you need a guardian of the estate to do that for the minor. Most of the time, if a minor has a natural parent, though, then they have someone in place, for example, to determine where they live, to make sure that they are fed and clothed, to make sure they go to school and that they get medical care. That's what the parent's role for a minor. When we're talking about a guardianship of an adult, it's because the adult either has some lifelong disability or has some sort of age-related cognitive loss that is preventing them from managing their own assets or from making their own decisions about their medical care, protecting themselves, feeding and clothing themselves, or making sure that they maintain a proper dwelling, a safe dwelling for themselves. And that's where we might have to have a guardian of the estate for the adult, like we might have to have for the minor, or we might have to have a guardian of the person for the adult. And that's really divided between who's going to control the money, the guardian of the estate, and who's going to take care of the person. That's the guardian of the person that does that. Sometimes those roles are combined, and in North Carolina, that's called a general guardianship. Some other states might call these a conservatorship when they're handling money, but in North Carolina, that's all called guardians.
I recently was working with a client, helping them go through some of these things and work through some of the issues that they were faced with. If there is a senior adult living alone and they have family members, a daughter, a sister, other family members, but that senior adult is living there and they're not making wise decisions, but they haven't been diagnosed, or somewhere they've been scammed and they've lost a lot of money. What kinds of things does the family need to know about that? Can the family be held liable for that?
Unless the family is engaged in some sort of illicit behavior where they're doing this, or if maybe the person did put together a plan in order to avoid this guardianship, and they put together a trust and named a trustee, or they put together a financial power of attorney so that someone could pay their bills for them, or did a healthcare power of attorney so that they could designate one of their children, for example, to make their medical decisions. If someone is acting under the auspices of one of those documents and not properly carrying out their fiduciary duty, then there could be some liability, yes. But if none of that has taken place and the family is just, for lack of a better word, ignorant of what's going on, then there probably wouldn't be any liability. I will point out, and you don't see this often, but North Carolina actually has a statute. It's in our chapter on criminal laws, and it's a misdemeanor not to support your parents. If you have parents and you're able to support them and you don't do that, then you could be held criminally liable. Theoretically, I have never seen that happen, but it's on the books. What do you do if you see something happen with an elder adult who things just aren't going right? Every county in North Carolina has a Department of Social Services with an Adult Protective Services division. You can call and file a report, and I believe that you can do that anonymously as well. I've had to do that when I've seen things going on with some of my clients, and it's not a fun thing to do, but sometimes it's necessary. I have also been involved with guardianships for adults that came across my desk because there was an Adult Protective Services report filed. And it's sad when that has to happen, but it does have to happen sometimes. I think the best thing to do is just for the family to stay in touch with the person, to show their concern, to not be pushy about it, but just to make sure to talk and ask questions. And does something just not seem right?
There is a question. There are bundles online, Mama Bear, LegalZoom for legacy papers on retirement. Are those sufficient to cover us?
Those types of packages often can do what you need for them to do, but I would caution you whenever you use something like that, there could be other things in your particular situation. An attorney is going to sit down with you and work with you and talk to you about your particular situation and might see things that you're not aware of that are issues or could become issues. And if you're using an online package to do something like that, those issues might not be reflected into a package plan that you might put together, whereas an attorney is going to draw that information out.
How do we find an attorney that can help us? Is there a website?
The state bar, ncbar.gov, has an attorney referral service, and they can tell you of attorneys in your area that practice in different fields. If you're looking for someone like me, I would say look for someone who does either estate planning, wills, trusts, and estates is another term that people often use, or elder law, if you're particularly interested about that.
I do want to thank you, Justin, for being here today. This is so important and I am so passionate about it, but thank you so, so much. I'm really thankful that I've had this opportunity to talk to you because, as I said, this is a true passion for me. I went through this with my parents, with my dad, and I learned the hard way about all of the things that Justin's been talking about. I learned the hard way that there's a 5-year look back period. I learned the hard way that you can't just put things in a trust, change a will, or do things, that there has to be some order. That's it for today. Justin, any last words, any advice to everybody?
No, it's just that I had a similar situation to yours that you had with your parents. I had with one set of my grandparents. My maternal grandfather had dementia, and I watched that progression, and regression actually is a better word for it, and watched what my grandmother went through to take care of him. It wasn't the same sort of financial tribulation that you describe because my grandmother kept him at home until 5 days before he died. But watching how that disease affected him, it has helped me to better serve my clients.
Well, I thank you for that. And I thank you for the work that you do. You're serving a very underserved community with the Hispanic community and the LGBTQIA community as well. Thank you for being here today. Thank you all for joining me. Please contact me. You can get me at judy@butlercounselingsolutions.com, and I'll be glad to make sure that any question you have is answered. So I'll be glad to help you in any way I can. Thank you, Justin. Bye-bye.